You're on record for what's been documented as the second regular review for both parents in this file and your permanency planning hearing. May I have the names of our participants, please?
Good afternoon, Your Honor. Nicole Underwood, lawyer guardian ad litem for the minor child.
Ms. Saja Thomas, counsel for the department. Ms. De La Garza.
Randy De La Garza, the foster care worker with Fostering Solutions.
Michael Brooks, I'm the attorney for Harold Hollis.
Okay.
Harold?
Yeah, Harold Hollis.
Michael McFarland, representing mother. Please introduce yourself.
Sorry.
Erica Hollis.
Thank you. All right, Ms. Underwood.
Your Honor, I was able to meet with the minor child at her school this last reporting period. She is doing very well there. She was excited and happy to see me. I've become quite familiar with her over the last several months. Her speech is just blossoming. We were in a room where there was several little stuffed animals and things on a desk, and she was going through and identifying all the animals and talking to me about them. She is thriving not only at school but also in her placement. She's very familiar with the placement. Enjoys being around her cousins and is thriving. She now has classes, which I think she may have had at the last reporting period as well, but there was one issue where she needed to go either to urgent care or the ER. She had what seemed like an asthmatic episode, but that was treated appropriately, and I believe she has an inhaler now for that. I had to ask the court for an ex parte order, which this court granted, allowing the placement to take the child on spring break, as the parents were not willing to agree to that. But other than that, her needs are being met in her current placement. She's in a least restrictive environment, and I believe that staying there continues to be in her best interest.
Thank you. Testimony today, Ms. Thomas.
Thank you, Honor. I'll ask Ms. De La Garza to be sworn in at this time.
I swear witness stand.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Ms.
Right.
Thomas, whenever you're ready.
Thank you. Ms. De La Garza, you've prepared a court report for today's hearing. Your cover page indicates that there are the case service plans for the parents, the initial case service plan through Orchard's Family Services, a couple of certificates from the MSU Extension regarding mom's completion of a couple of courses, and then a correspondence email from Orchard's. Are there any updates or modifications that need to be made to any of those documents that I've listed?
No.
Okay. And the case service plans that are included in the court report, those look like they are not signed by the parents. Do you have any updated signed versions at this time?
Yes, I do, and I brought copies with me today.
Okay. And have you been able to circulate those to Mr. McFarland and Mr. Brooks and Ms. Underwood?
No, not yet.
Okay. As it relates to the parents, at the last hearing, the court changed the goal to a dual goal of reunification and adoption. At this time, how would you describe the parents' progress towards reunification?
I would say that they are partially participating in services. Both of them during this report period have changed therapists due to being dropped by their previous therapist that they had. They have not completed the SUD evaluation yet, although it is my understanding that it's scheduled, but there was no release time, so I'm just going off of what parents had stated to me. And they have been participating in the Orchards program since they were referred for a second time.
Okay. In the Orchards report, there's an indication that the parents reported to that worker I don't feel like they're being listened to in various areas of the case. Were you able to address that with the parents during this review period?
I didn't address that specifically, but we have had, family team meetings scheduled with them every other week, with myself, the parents, and Miss Moore.
And during those family team meetings, your report indicates that they're used to, I think, track the progress of the case service plan for both the parents and their compliance with that. Are you able to utilize those family team meetings and achieve those goals with the parents?
We have been able to utilize those meetings, on a couple of the meetings. Mr. Hollis has become argumentative, about things that we've previously talked about. And, there was one meeting that they didn't show for, but other than that, yes.
Do you have any concerns about the family continuing to work with Miss Moore?
Mr. Hollis has stated that he refuses to work with her, refuses to go to her office. We've held the meetings over Zoom, because of that, but, unless Mr. Hollis has asked something directly, does not answer usually.
I didn't hear the last part.
That unless Mr. Hollis has asked something directly, he doesn't usually answer any questions.
And during these meetings, has Miss Moore indicated what she would expect to see from the parents in order to recommend parenting time be reinstated?
Yes, she has, and I complete the FTM form each time and send it to all parties also, just so that we're all on the same page.
Okay. And what is, I believe this is in your report, but can you just highlight and articulate for the record what exactly is not being done by the parents that Miss Moore is still recommending parenting time remain suspended?
They have not completed any drug screens. They did complete one today at 2:30 before coming to the courthouse, but they were hoping that after taking the one drug test that they would be able to get a visit today, but I explained to them that we don't get the results right away, and it's something that they need to be continuously working on, not just do it one time.
And is drug screening the only thing that they're not doing?
They have not done the SUD evaluation yet. They have, like I said, they have participated with their therapist. Mr. Hollis has attended all of his therapy appointments, but his counselor still chose to drop him in February. And Ms. Hollis was dropped because of so many no-shows that she had.
And is it Miss Moore's recommendation that the parents demonstrate stable compliance with their case service plan before she's willing to recommend parenting time?
Yes.
To the best of your knowledge, has there been any impact on the child since the parenting time has been suspended?
The impact that I've seen during home visits and have also heard from the caregivers is that she is doing very well. They have her on a routine in the home and she's going to school, as Miss Underwood mentioned, and she's just thriving in the placement. She's does well with the household members. She's bonded to the caregivers, and a lot of the behaviors that she was showing during parenting times, like the waking up having nightmares, hitting people, trying to kick people, things like that, have all disappeared.
Is there anything, I know that one of the concerns in the report, the reason this case came under the court's jurisdiction also related to domestic violence. Has there been any progress on that issue?
No, they both continue to state that there was no domestic violence, and minimize what has previously been reported in court. So no, they have not participated in any services regarding that.
And have referrals been made?
Yes, I did give Mr. Hollis the information for the DVAP program through John Bailey.
And what about for Miss Hollis?
I know the orchards worker is touching on that subject, and they're supposed to be working on that through their therapy sessions also.
Do you mean in their individual therapy with their respective therapists?
Yes.
Okay. Do you have releases with their individual therapist?
I do, yes.
Okay. And have you been able to provide their therapist with like their psychologicals or any court orders or like the case service plan?
I did send them to Erica's new therapist. I sent them over to Mr. Hollis's therapist, but she is on vacation this week, is what my understanding is.
Okay. And at this time, do you believe that there's been sufficient progress to continue towards the goal of reunification in any form?
I don't know.
Okay. The current caregivers for the child, are they willing to provide permanency through adoption?
Yes.
Okay. And I know that there had been some issues in the beginning of this case with harassing behaviors towards the relative caregivers. Has that continued or has that subsided? Is there any update on that?
I do know that a acquaintance of Mr. Hollis showed up at their home one day. I'm not sure if that has anything to do with the parents or not, but the family is worried about that and they're getting a security system because of that.
All right. And can you just briefly summarize the risk of harm to the child if the court were to return the child to the parents' care and custody today?
Yes, I believe that she would be at risk for witnessing domestic violence in the home. Also the substance abuse, since they have not completed anything in that area. I'm not sure if they are using substances or if this is a struggle of theirs. Also the mental health concerns continues as they've not been stable in therapy with the same therapist throughout the case, and also just the overall stability for the parents.
And have you noticed any benefit from services? Like, are they engaging better with you?
No.
How are their interactions with you?
I would say that Mr. Hollis continues to be very argumentative. He doesn't let myself talk usually or Miss Moore, especially if there's something that he does not agree with. And more recently, we have noticed that Miss Hollis has also been more argumentative when talking with workers.
Thank you. With that, Erin, I have no further questions of Ms. Elgarza. I would move to admit the court report with the attachments. With the understanding that there are signed case service plans in the courtroom, I believe we would just need someone to hand them to the court.
Are they gonna be different than the ones that are unsigned?
They're not different. The only difference is that they sign.
Okay. All right, objection, counselors?
Objection, my client acknowledged that she has signed a case service plan.
No objection.
Objection. Thank you. They are received and we'll look for those signed case service plans to replace the ones I have. That's all. Questions, Mr. McFarland?
You testified there's no evidence of refraining from drug use, correct?
Yes.
Well, of course, they've been to therapists, they've been to various other meetings. I don't see a single commentary in your report where anybody's reported or suspected them of using drugs, correct?
That's not something that the therapist touches on with them.
Well, if a therapist thought that they were high, they would put that in a report, correct?
I'm not a therapist, I'm not sure, but I would hope so, yes.
Okay. So nobody's reported to you that they've been high or under the influence of drugs, correct?
No,
You don't have any police reports in the last reporting period where police have been out to their house for incidents or reports of domestic violence, correct?
correct.
Nobody has reported to you that they have seen them in a domestic violence situation, correct?
Not in the domestic violence situation, but Miss Hollis has told me that one of the barriers of her getting to the office to drug screen and things like that is that he will not allow her to use the truck.
That's not domestic violence, right?
It's a controlling situation, yes, I believe.
Maybe she's a bad driver. That could also be another reason, right? Let me rephrase. Have you asked her specifically why she's not being able to use the truck?
She has stated that he will not allow her to.
Did you ask Mr. Hollis why he does not want her to?
No.
Okay, so you're speculating, right?
Sure.
If the drug test comes back negative that they took today, what are your thoughts then about some type of supervised visit?
So I know that Ms. Moore has the discretion currently, and she has stated that she wants to see them participating in services, not just more than one time, but continuously.
Where should my client be focusing the majority of her efforts on the case service plan, in your opinion?
I would say continuing taking medication and doing her medication reviews and continuing or participating in therapy consistently.
My understanding, she's not met with her new therapist, but when she does, do you wish for her to sign a release?
She has met with her and she's already signed a release. I've already spoken to her.
Okay. No further questions.
Mr. Brooks,
I've been in this case since the beginning, very first hearing. I have heard allegations against my client that he may be a drug user. I've seen no evidence of it, none. He took a test today. When will that be available?
We usually don't get them for a couple days, so probably the middle of next week or end of next week.
Are you expecting this court to take based on no evidence that he's a potential drug user?
Can you repeat that? Sorry.
I can't hear you.
Can you repeat that?
Are you asking this court to take it as evidence that my client is a drug user without having submitted any evidence of any kind that he is?
That was one of the reasons that the child came into care, and he hasn't screened to show that he's sober either.
Wait a minute. Sober alcohol or sober street drugs?
Of anything,
Pardon me?
of anything,
Do you have evidence of any of that?
just from the removal petition.
Which has yet to be proven he was or is a substance abuser of any kind. Isn't that right?
That's why we asked for him to take do an evaluation.
I'm very aware of that policy. I want to know if you have positive proof you can lay on that judge's desk and see.
I'm gonna object as the parties have agreed to take drug screens as a part of their case services plan. And part of the report indicates that non-testing shall be considered a positive drug screen.
yeah, as I recall it, Mr. Brooks, the concern for your client was the prior drunk driving and concern that use of alcohol could result in domestic violence within the relationship. and concern for Ms. Walker was that some of the behavior that she's exhibited, which is indicated to be as a result of mental health, could have also been complicated potentially by substances, including but not limited to alcohol. So that was the reason for the request that they both submit to an evaluation.
All right,
Is that your impression?
Yes,
Good, that's the impression I intended to convey.
yes.
Thank you.
who is the unnamed acquaintance of my client that allegedly went over to the foster family's home?
I don't know the name, but the family stated that they do know that he is an acquaintance of Harold, and they have him on video.
Somebody who's not here today knows, that guy knows this guy.
Yes, because he gave them their address.
That is not evidence. Shh, be quiet. So we have no evidence that my client had any connection at all to do with A, the decision, or B, the action of harassing those foster parents, nor do we know specifically what the harassment was. Do you contest what I just said?
They do have on video what he stated,
Who asked?
the caregivers.
You don't have.
I don't.
Mr. Hollis, apparently, according to your testimony, attended all of his therapy sessions with the, what is that therapist's name, who you say is dismissed?
Kim Yoder is the one that dropped
Jim
him.
Yoder,
Yes,
and yet she's telling you she has dropped him?
that's correct. I did email with her today to try to get more explanation because Mr. Hollis stated he wasn't aware why he was dropped either.
Was he threatening her? Was he argumentative with her? Was he refusing to attend the meetings? What?
She stated that she felt he needed anger management and was not willing to work towards the goal of getting his child back or visits back. So she tried to refer him to someone more experienced, but he refused.
Like who?
I'm assuming the one that he's working with now.
When's the last time Mrs. Hollis filed a complaint for domestic violence?
I don't know the last time she filed one, but she's spoken with me about how she's wanted to move out because of how he was acting towards her and she doesn't want to work with him and things like that, and then turns around and says that they're back together and working together.
I'm going to object because I don't believe that's in this reporting period. I believe that was in the last report.
Would you clarify? Was
Yes,
that recently?
That was the last reporting period.
Okay, thank you.
Whose truck is that the family is using for transportation?
Ms. Hollis stated that it's Mr. Hollis's truck.
What specific harm would be done to this child if these people were allowed supervised visitation?
Just the parenting skills that we've talked about in previous court hearings. And again, we're not sure if they're abusing substances at this time. They need to continue to work towards or participate in their services.
I have nothing further.
Questions, Ms. Underwood?
Approximately how many drug screens have you offered the Hollises in the last reporting period?
It's been once a week that I've offered.
So several.
Yes,
And until today, how many had they attended, or how many had they actually submitted to?
none.
Do the Hollises seem to be benefiting from any of the services that they're engaging in?
I don't believe so because it's the same arguments that they're trying to have with workers and service providers if they're not being told what they want to hear.
What are the arguments that they're making that impede their progress?
They're continuing to state that they should be able to tell the child that that the caregivers are not her mom and dad because they've heard her say mom before referring to the caregiver. They argue that they feel they are doing everything and all of their services and feel like they should be getting a visit instead of focusing on actually participating in their services consistently.
Have the Hollises taken any accountability for why their child is in foster care right now?
No.
Thank you. No further questions.
All right, any redirect, Ms. Thomas?
No, Your Honor.
Mr. McFarland, any more questions?
Brief recross, as far as domestic violence, you don't suspect that the parents might engage in domestic violence with each other if they were to have parenting time, do you?
During parenting time?
Right.
Is that what you're asking? Ms. Moore has stated that she feels that Mr. Hollis is very controlling during parenting time visits that have been supervised.
So that could be resolved for my client for her having individual visits, couldn't it?
Well, and part of the reason that her visits were suspended also was because she does not engage well with the child during visits.
My question was domestic violence, wasn't it, not engagement? I'd ask that be struck, Your Honor, as not directly answering my question about domestic violence.
Response, Ms. Thomas?
Your Honor, I mean, I think my main argument is rules of evidence don't apply at these proceedings. Why they're pretty lax. We allow a lot of testimony to go and a lot of poor-formed questions to be asked. So I think that it's a relevant answer to the issue of continuing to suspend parenting time. And I also think the court's very aware of the concerns that were brought to its attention by Ms. Moore.
Would you like to weigh in, Ms. Underwood?
Your Honor, the follow-up question that Mr. McFarland said was, could she just have individual visits? So I believe that Ms. Della Garza's answer was based off of this very general question.
I would tend to agree. So I'm going to overrule the request to strike that testimony, Mr.
Thank you. As far as supervised visits, if a parent appears under the influence of drugs, it's your policy that they're not to have visits, correct?
Correct.
There'd be no harm with controlled substances at visits if they're not able to have a visit, if they appear under the effect of what you might think might be drugs, correct?
That's not the only concern, but yes, correct.
Nothing further.
Mr. Brooks, any other recross?
No,
Ms. Underwood?
No, Your Honor.
Thank you for your testimony. May I return to your seat? If you could locate those signed case services plans, I'd like to get those swapped. Deputy Ames, if you could please, Ms. Della Garza is going to hand over some signed exhibits in exchange for our unsigned. Thank you.
Back there.
thank you.
Sure.
I acknowledge I've received a copy of signed.
So have I.
Gentlemen, Ms. Underwood, any objection?
No objection.
Well, they are received, they are signed. All right. Any other witnesses, Ms. Thomas?
No, Your Honor.
Mr. McFarland?
Wishes to testify today. My client wishes to testify.
Very well. Erica Hollis, is that right?
Yeah.
All right, come on up.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Don't forget there's a step here.
Go ahead whenever you're ready.
Let's address a couple questions. First of all, why is the reason that you agreed to do drug testing today?
Well, because for one, I just decided, let's just do it. Trying to get our kid back, trying to get visit, trying to get something.
What about future drug testing? Are you okay with that?
Yep.
Domestic violence, have there been any domestic incidents between you and Mr. Hollis since we last met here in court?
Nope.
Harmony on the marital front, is that what we're hearing?
Yeah, yes.
Have you read your case service plan?
Yeah.
Okay. Do you have any questions regarding what you're supposed to do?
No. I know what I'm supposed to do, and there's just one slight issue on the whole service plan thing.
What is that?
I didn't get dropped for no shows from counseling.
Okay.
I did call both days, and they said my therapist was out sick. And then both days she was out sick, and then I got an email from my therapist stating that she was dropping me because I did no call, no shows. Now, to me, that's calling. I called both days.
You called both days and your testimony is that your therapist was sick?
That's what they told me on the phone, that she was sick both days.
But you have a replacement therapist, is that my understanding?
Yeah, I got a different therapist at a different place because I was
Okay.
done with that.
Who is that therapist?
Her name is Mariana at River Oaks.
And you've not met with her before, if I recall.
I met with her twice so far. Well, today was the third time.
Did your personality seem to click pretty good?
Yeah.
You wanted to express your feelings today, your thoughts about parenting time, correct?
Yes.
What are your feelings?
My feelings is, we've been going to counseling. I've been taking my meds every day. Yeah, we did a drug test today. I see us going forward, not backwards.
You get your prescription for your meds.
I get it through ACPC still.
Okay. You've been regularly meeting with a therapist through ACPC?
Yeah.
Who's that?
Robert Shaw.
You think the medicines are helping you out?
Yes, but I am in the process of changing doctors. Because I want to get out of ACPC altogether because they dropped me as a patient for no reason. So I just don't even want to fool with them. So I'm getting a different doctor. So that will be changed.
You know that the goal request from the agency is to change this to adoption, which means a termination trial of your parental rights. You understand what they're asking for.
Yes, I do, and that's not gonna happen. Cause I don't see how they can change it to that when we are trying. I see us trying.
Okay.
I mean, I think we've done more now than we did the last report.
Is there any way that we can perhaps assist you to be more compliant in their eyes?
I mean, I'm trying the best I can, you know, I mean, I get dropped for no reason, so then I gotta start over, I feel like, you know?
Well, the workers made an issue that you don't have access to a pickup truck. I don't know anything about that. Is there anything you want to share with us on that?
Well, the last truck got wrecked, so no, we don't have Harold's vehicle anymore. We are using his friend's vehicle at the time. We're getting around to.
Do they not trust your driving skills?
Well, he's not my friend, but that's Harold gets permission to drive the truck.
Okay, so you don't have permission to drive the truck. Is that what we're hearing?
Yeah,
Okay. Any other way that we can assist? Do you need to?
I'm working on
Hang on.
that vehicle, I'm
Do you-
working on
Do
it.
you need Lenawee transportation vouchers so you can go to things?
See, that's the thing, I know Dollar Ride does not come up to my house because I've already asked.
Well, Dollarade may not, but how about Lenawee County Transportation? Have you checked with them?
I just didn't call anybody else because I figured I live out in the country, so I'm figuring a Dollar Ride don't come out there, I'm sure nobody else is gonna come out there. Unless I got buku money, you know, to spend on a taxi cab, then I might be able, I mean, it's $33 to get from, with Jeff rides, you know, $33 just to get from Sutton Road to Adrian. I mean, that's a lot of money, just one way.
Would you attempt to call Lowell Transportation, then get vouchers if they would indeed come out?
Well, if I could,
Okay, you have a telephone.
yeah.
Okay. Any other way that you think we can help you?
No, that's about it.
Anything else you don't understand?
No,
We're gonna leave this for other attorneys to ask you questions if they want to then, okay? Okay,
yeah.
Questions, Ms. Devitt?
No, Your Honor.
Mr. Brooks?
I have one, but I don't think I'm gonna ask. Thank you.
Why did you wait until today to take your first drug test?
Like I said, I just wanna try to get my kid back. I'm trying to work towards it. I'm trying to do it, but then I feel like I'm getting told that we're not doing it, but we are. We're trying to go forward here.
But why have you not taken any before today, is my question.
Because honestly, I don't trust any of them. I mean, they're already lying about me getting dropped as a patient from my counselor. That's not why I got dropped. That's not what happened. At least, you know, what they could have done was, hey, we got told Erica did no call, no shows. But really, what happened is what Erica called, right? But it doesn't say that in there, does it? And that is the truth.
No further questions.
All right, any redirect, Mr. McFarland?
I do not.
Thank you for your testimony. You may return to your seat.
No further witnesses.
Mr. Brooks?
Harold Hollis. You don't wanna go up? You sure?
Raise your right hand, please, sir. Do you swear or affirm to, can you look at me, please, sir? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yep.
Harold, we're gonna talk a little bit here, okay? You know I've been doing this longer than you've been alive, don't you?
Yeah. Yeah.
I am aware that you have anger issues, and you have awareness that you have anger issues, right?
Yes.
So let me ask you a simple question. In your whole life, have there ever been things that didn't tick you off,
Yeah.
but not lately?
No.
And so you continue to oppose and to argue and to fight, right?
With who?
The department.
I'm trying not to do, I try not to say anything unless they ask me, and that's what I've been doing. If they ask me something, I say something.
Don't you recognize that that in itself is a form of opposition and arguing?
No, no.
Well, it is. You may not be aware of this, so I want you to hear it plain blankety blank English. All this department has to prove to the court at this point is that you will not cooperate with them and thus do not benefit from the services they seek to provide you. You can be the best damn little parent in the world. But if they say, he just won't go ahead and work with us, which you won't, you realize that's all they need to terminate your parental rights. That's not this judge's decision. It's not mine. It's not the prosecutor's. It's the law. I've never told you this before, but I'm telling you now. Keep doing what you're doing and you're gonna lose your child.
What am I doing? I mean, I do what, I'm going to therapy, I'm doing.
Listen to me. You're going to therapy and you're telling them they're full of BS.
No, that's not, I've never told that counselor anything, I've talked to, no, that's not the truth.
So you're being fully cooperative and open with this counselor.
Yeah, with the other one too, and all of a sudden after they talked to her, or whoever she talked to somebody, then the next time I came, she said, well, I can't help you no more. After they talked to them people from here, yeah. Whoever she talked to,
Harold, can you be more cooperative?
I thought I was being cooperative.
You're not. Can you be more cooperative?
I think I'm more cooperative.
Quit taking them on.
I'm not taking anybody on. I ain't taking not a soul on,
What do you call not taking a drug test?
because if my word ain't good enough, I don't trust her or them, first of all. I don't trust even taking it today with them. I wanted to do it here at the courthouse.
There have been thousands of people have gone through this court system, with me present, who have taken those drug tests. I want you to take those drug tests. Will you do it?
I just did one today.
Yeah, and you missed how many before?
Actually, they never asked me. They left it on Eric's phone about me. They never asked me to do it. But anyway, yeah, problem. I'll do it.
There shouldn't be any
I'd
problem
like to
about the
hire
things
somebody
that
of
you-
my own to do it.
Sir, do you, that's not gonna be the same.
Okay.
Do you understand you're on the edge of the cliff? One more step in the direction you're going in, and your child's gonna have a different last name. Are you aware of that?
Yeah,
And your wife can say, well, that's not gonna happen. Nobody's gonna ask your opinion or hers. Nobody.
they already got their mind made up anyway, so.
So change it.
You know what, I don't know
Sir,
what you want me
I
to do.
change people's minds for a living.
Kiss their ass, I guess, right? Okay, I'll do whatever you say.
You want your daughter back.
Yeah, I want her back.
What does it cost you to cooperate with them instead of being objective or,
I ain't been objective to them people.
yes, you have.
No, I haven't, but either way, if you say so, I'll do whatever you say.
You want your daughter back?
Yeah, I want her back.
Do what I tell you. Do what I tell you. Is there anything else you want to say?
No, I didn't want to say that. I don't want to say, no, I'm good.
All right,
Any other questions, Ms. Thomas?
No, Your Honor.
Mr. McFarland?
No, thank you.
Ms. Underwood?
No, Your Honor.
Thank you for your testimony, Mr. Hollis. You may return to your seat. Anyone else you want us to hear from?
no,
Ms. Underwood?
No, Your Honor.
Comments in closing, beginning with Ms. Thomas?
Thank you, Your Honor. I was reviewing my notes from our January hearing, and it really seems that there hasn't been progress in the last 2 months. And for those reasons, Your Honor, I believe the court is just very aware of the issues and concerns that brought the child into care. His child was removed back in June, and we still haven't been able to progress towards, well, at this point, to look at reinstating parenting time, let alone progressing towards expanding parenting time and unsupervised parenting time, and knowing that the child would be safe in their care. So for those reasons, Your Honor, we are asking the court to consider the singular goal of adoption, and expecting and anticipating a termination petition from the agency, and set it for a 90-day review. Of course, efforts will continue to be made towards reunification, as always. But I really think the focus should shift towards what this kiddo needs. She's clearly thriving with the stability that's being offered in her placement family, in the routine, being around her foster siblings, and having a normal family life. It's really unfortunate that we haven't seen a change in the, I guess, taking accountability for why this child's in care. And in 9 months, that hasn't happened. And still really deflecting and being distant and hostile towards our caseworkers and providers. And it just seems like it's everyone else's fault other than the parents. So, Your Honor, for those reasons, we are asking the court to change the goal, to order the termination petition to be filed, and to have a 90-day review. Thank you.
Comments, Mr. McFarland?
Oh, Your Honor, my client not being able to borrow a friend's truck, I don't really think rises to domestic violence, domestic confrontation, anything of that nature, Your Honor. No police reports, no arrest. Seems as though that's more speculation than anything else. And I probably had good speculation at that. As far as drugs, well, visits would not have occurred if they were under the influence of drugs. If they're supervised visits, they could easily be cut off if they were suspected under the influence of drugs. Client has signed releases, or if not, she will, my understanding, with this new therapist. She wants to move forward. She has been confrontational in the court before, but I can't remember the last couple of hearings ever being that way. I think she's acquiesced to, at least on the drug issue. She's given the sample. She'll continue to do that down the road. I would like, my client would like to see, the most importantly, for the court to consider keeping the goal for another review period, or a dual goal, Your Honor, and not converting it to a adoption, which is effectively a termination of parental rights. Regardless of how we call it, that's what it amounts to when that happens. So, and she does not wish for that to happen. Thank you.
Comments, Mr. Brooks?
I think it was the department's attorney who said this case is 9 months old. In the general scheme of things, it's not very long. I don't think the court will argue with me for 1 second when I say that Harold's not easy to represent. Harold now has been told on the record by his own lawyer, he is 1 step away from having his child taken away from him forever. And he is. You know it. I know it. He's been told that. I want you to give him more time than 9 months to change the way he deals with confrontation, which is to dig his heels in and fight against all logic. Because there's no logic in arguing this point when the cost is he's going to lose his child. There's none. Take the drug tests, listen to what the therapists have to say, talk to them, not just sit there and don't clam up. That's the hurdle we have to get past. Not drugs, not domestic violence, none of that stuff. Harold's refusal to listen to somebody and follow instructions he doesn't want to follow. He can continue to do that. That's what he wants to do. Nobody can stop him. But he can't kid himself anymore. And if that's what he wants to do, he might as well quit this court case now and put himself out of his misery. 9 months is too quick. Thank you.
Ms. Underwood?
Your Honor, I don't think anybody up here likes to sit here and recommend a goal change of adoption when the department's trying to make efforts to reunify a child with their family. However, this child deserves stability, permanency, and consistency. While we wait for the Hollises to get over this hurdle that Mr. Brooks indicates there is, we have a child who has spent nearly 2 years of her life out of their care. And in that time, she has been able to get a vision exam and get glasses, go to school with her peers, be in a loving and functioning household free from domestic violence. there's been nothing but blaming everyone else for their issues and their shortcomings. The parents have made probably the least amount of progress that I've seen on a case in 9 months. And that's not due to the lack of attempts and reasonable efforts, actually active efforts, in my opinion, of the department and the workers that have been put in place to try very hard to help this family. The bottom line is the parents have been given the opportunity to take accountability and to make progress for parenting time and reunification over the last 2 months. And they've really done very little. Showing up for one drug screen on the day of a court hearing is not enough to consider any progress at all, in my opinion. I would ask that the court adopt the goal change, or change the goal to adoption at this time. I believe it's in the child's best interest. And I would agree that there's been little to no progress that would afford the parents any parenting time at this time.
Thank you. The court finds all interested parties were given notice for purposes of today's review and permanency planning hearing. The goal was changed to a dual goal of adoption and reunification at the last review hearing in December. Today, we heard about the parents' attempts to engage with services. Mom has taken some extension education through MSU. Father, Mr. Hollis, has tried to begin engaging in counseling. I think that while Mr. Hollis stayed for the hearing so far today, that's also progress as far as I'm concerned. And I have to say, I think it did justice to his client that Mr. Brooks really took the time to speak very frankly with Mr. Hollis on the stand, and that Mr. Hollis did his best to try to understand what he was being told. There's no question that any progress whatsoever in this case would take a very significant amount of time, and the modicum of effort that we've seen this report period is only due in part to the overwhelming, frankly, and very gracious efforts of Ms. De La Garza, Ms. Brene Moore, and the other service providers that are tasked with trying to help these parents get out of their own way, to be perfectly frank. So there's no question that we have reasonable efforts, and I would agree even with Ms. Underwood on this point that we have very active efforts. We have Ms. Moore, Ms. De La Garza meeting regularly, trying to engage with these parents, trying to get them to understand what the challenges are in returning their child to their care. There's no question that both of these parents care very much about this child. But the lack of understanding as far as what the challenges are that remain in the way of reunification is very, very much apparent, as reflected in the court report and the testimony of Ms. De La Garza, and in the parents' testimony in and of itself. Ms. Underwood is not wrong. When we heard both parents continue to deflect responsibility for some of the challenges that resulted in their child being removed from their care, and the challenges that she faces. She had developmental delays, she needed glasses, she needed analysis for special needs. She now has an IEP for speech and language. She's begun preschool and is making strides in some of those areas that she was previously prohibited from making strides in because her parents, frankly, had her in a household that did have abuse and neglect dynamics associated with it. Her behaviors demonstrated that at the time of her removal. She demonstrated behaviors consistent with food insecurity, hoarding food and stuffing herself during meals. She demonstrated fear of men and conflict, some traumatized behaviors. She has been removed from the care of her parents since June 22nd of 2024 and is making strides in those areas. Ms. Walker did have a brief hospitalization at the end of December and was poised to re-engage in psychiatric care. I'm going to ask Ms. De La Garza in the next report period to really do her best to secure the analysis that was performed both during that hospitalization as well as through ACPC care. And that's going to depend a lot on Ms. Walker cooperating to get those records around. At this point, I still don't have an official diagnosis for Ms. Walker, what her goals are in therapy, what progress she's made. And that's just as much, if not more, on you, Ms. Walker, as it is on Ms. De La Garza, because Ms. De La Garza is here to report on the progress. And it's not on Ms. De La Garza to go to your house, to pick you up, to get you to sign these. No, all of these things are set up for you to demonstrate that you are able to become a healthy person so that you can become a healthy parent. It's not on Ms. De La Garza to make you into a healthy parent. It's on the two of you to show us that you can do it, to avoid things that were in place when your child was removed from your care. That's it. That's the long and the short of it. Mr. Brooks is right. This, and Ms. Underwood is right. This is a case where we've had very little progress in the 9 months, almost 9 months that your child has been removed from your care. The next 3 months will be imperative for you to show us that you're serious about trying to understand what the barriers are in making progress. I'm going to leave the goal as a dual goal of adoption or reunification. But I can promise you this, at the next hearing, if there's no progress made, it's going to be adoption, and there's going to be an order for the department to file a termination petition within 28 days of that review hearing. So that's the bottom line. And I wish you the best of luck in overcoming some of these barriers that have been overwhelmingly identified to engage in these services and to do what Mr. Brooks tells you to do, Mr. Hollis, if you so choose to accept that challenge. In the meantime, the child will remain in her placement that is the safest and least restrictive under the circumstances. Thank you, Ms. De La Garza, for your efforts. I know this is an especially challenging case, and I want to take a moment to say that I appreciate you, and Ms. Brene Moore, and please express my appreciation to her as well. I know this is a challenge. All right, so the next review hearing. Let's go to June 2nd at 1:30 p.m. Review hearing and permanency planning hearing as promised. Unless there's any questions, that's all for today.
Thank you, Your Honor.
You're welcome. You're welcome to wait in the
Thank you very
hallway.